Thank you all for coming. I'm really having a good time with these lunch and learns, and I really hope that you all are enjoying them too. The attendance has been pretty good. And if you ever have a topic that you want to know about, let me know, and we'll get somebody in here to discuss it. Our speaker today is from the Midwest Kentucky SHRM, and SHRM is Society of Human Resource Management. And this is LaSenna Powell, and she is the current president. She's a graduate of Murray State University, and she's going to fill your brains with some helpful information. So
I'm going to try to. Okay, so what's my group? What's the makeup? Are any of you guys in human resources or, yeah?
I guess we kind of, yeah.
Kind of deal with some of the responsibilities that an HR person would normally deal with? Okay, good. Well, just a little quick background on me. I started out my human resources career at Tyson Foods in Roberts, Kentucky. I worked there for 3 years, and I started out as a supervisor trainee straight out of college, and I was promoted to a HR supervisor. And Tyson has quite a few employees. When I was there, it was about 1,500. And the majority of those employees were in the plant. I actually dealt with the manufacturing side of it and the live production side of it. So I got to deal with the hatchery and the feed mill and the truck drivers and all that stuff. So it was a good training ground for somebody that starts out in HR, because you deal with a little bit of everything when you've got that many employees in one organization. But it was union. We dealt with the UFCW there, which is the United Food and Commercial Workers. And then when I left Tyson, I went to Lear Corporation, which is now IAC. And they manufactured internal automotive components. So, you know, the door panels, I can't remember the name of them. I want to call them head frames, but that's not the name of them, but you know what I'm talking about. And I worked there for 2 years. It was also a union, but it was a different union. And it was the United Auto Workers. And after I left there, I went to Rexam, and I was at Rexam for 7 years. And if you've been keeping up in the news, you know that Rexam was recently taken over by Berry Plastics. So I worked in the Madisonville plant. Now, luckily, I took the job that I currently have before they closed the plant, but I was a Berry employee for about a week. But I worked at Rexam, and we made injection molded plastic bottle tops at Rexam. And then I went to Lana Frost, where I'm at now. And I've been there for about 1.5 years. And of course, Lana Frost does lunch meat. So I've been in manufacturing the whole time that I've been in human resources. And it's good that I have some union and non-union experience, because when I went from union to non-union, it was a big eye-opener. You know, you deal with people differently. The union, in my opinion, I have to say that whenever you refer to the union, in my opinion, the union can cause some hurdles when you're trying to deal with employee relations issues. So it's kind of nice to be in a non-union facility, because it kind of gives you a little more leeway to deal with people and kind of directly address issues. So that's a little bit about me. I have 2 kids. I have a son who's 18. He's currently at the Naval Academy. Finally got him out of the house. I'm working on one more. I have a daughter. She's 14, and she's currently a freshman at Madisonville North. So that's just a little bit about me and my work history, okay? So what I wanted to do today, because Vanessa told me that you guys wanted to kind of get some HR basics and possibly some recent developments. And what I try to do is condense that into maybe an hour-long presentation as much as possible. When you talk about HR, you talk about a whole gamut of things. So I thought, given I've been in HR for 14 years, I could kind of throw you guys a presentation together real quick. And then I started sitting down and trying to go through it, and I was like, ooh, that's a lot of information. So condensing it was really hard, but hopefully I've done a good job of trying to give you guys a basic idea of what human resources entails, and some of the recent developments that are coming up some of them are pretty big. Now, if you have questions during the presentation, just shout them out. I want to try to keep things informal. But please don't hesitate to ask. Sorry, I got a little strap here just out of place. Okay, so when I started my human resources career, it was already human resources. Now, some of you may remember when there was just a personnel department, and all they did was handle payroll and benefits. And the personnel person really wasn't somebody that was looked at as a strategic partner in the organization. Now, human resources is growing and expanding, and we're actually expected to be a strategic partner for the organization and guide the organization in how we manage people. So I'm an HR generalist. I have to know a little bit about everything in order to do that. So I usually do quite a bit of, training and different things like that to keep up on the changes that are going on in the HR field. But in my mind and in my experience, HR can pretty much be narrowed down to about 6 or 7 different categories. And that would be recruitment and hiring, which is something at any given point, I may be doing 80–90% of my time, maybe doing recruiting and hiring individuals for open positions. In July of last year, we added a whole production line and we had to hire like 25 people. So when you're trying to get people in for interviews and screen and all that stuff, it takes a lot of time. So recruitment and hiring, in my opinion, is one of the biggest responsibilities we have as an HR person. And then there's also compensation, employee benefits, training and development, employee relations, terminations, and of course you can't talk about HR without talking about the legal responsibilities that we are relied upon in the organization to try to guide people through, okay? Human resources has to keep us out of legal trouble, So that's a big part of what we do. And the next slide that I have in your packet is my interpretation of how I think all of these areas are kind of linked together. In my experience, each one of these areas affects the next one, okay? And they all kind of play together. So, it's really important how we go about recruiting and hiring employees. Like I said, we spend a lot of time doing that in the HR profession. And part of whether or not we can recruit and hire the individuals that we need in the organization, because with the changes in the economy, there's skills shortages in different areas and different things like that. So having a competitive compensation and benefits package is a big part of being able to recruit the talent that you need in your organization. One of the biggest positions that we've had an issue with trying to get people in is maintenance techs, and you wouldn't think that you would have a hard time finding a maintenance guy. But nowadays you do, because they've got a lot of different options, and everybody is trying to offer the best compensation and benefits package to try to get that talent into the organization. So those two things play together so much, especially with salaried employees right now. We've been looking for a food safety manager for 3, 4, 5 months, and we've interviewed a lot of people. And how much we can offer them salary-wise and our benefits package plays a big part in us being able to recruit for that position. With the economy changing and jobs being hard to find and people leaving organizations, because the people we're trying to recruit with experience, they've been in the organization for several years. They've got their vacation time, they've got their pension, they've got their, retirement benefits, and they're not real quick to make decisions to leave those things. So in order for us to recruit those people, we have to be competitive with our compensation and benefits. So those two things play together. And then the compensation and benefits package that we offer also affects employee relations. And employee relations, and we'll get into this a little bit later, is a big umbrella, okay? You're talking about whether or not the people that you have in your organization are happy and loyal to your organization. And there are a lot of things that go into employee relations. And one of the things, more so now than ever, is compensation and benefits. There's a lot of opportunities out there for people who have the talent that you're seeking. So being able to stay competitive with your compensation and benefits definitely plays a big part and affects how well you handle employee relations. And then training and development. One of the things that we do at Lane Frost is a pulse survey. And when we get into employee relations, I'll talk a little bit about employee engagement, because that's the big term that's being thrown around now. You want people who are fully involved and engrossed in your organization from top to bottom. So what we do is we give out this survey every month, and it has 5 questions on it. And they center around 4 different areas. And 2 of those areas is job coaching and professional development. And unfortunately, we don't always score as well as we would like to on those two things. And part of the reason for that is the makeup of the organization is changing a lot. You know, you're getting a lot more younger people into the organization, and they want a lot different things than the older workers that you have in the organization. They, you know, young people, and my son is an attestament to this, they think that as soon as they join your organization, they're your top talent. You know, forget experience. You know, I don't need that. I'm bringing all these other things to the organization, and they feel like they should be able to move up pretty quickly. You know, they don't want to pay their dues like some of us have done in our organization. So, you know, those people expect to be trained and to be developed and to grow with the organization. So training and development, in my mind, and employee relations work together a whole lot, because that's part of keeping those employees happy. And, you know, whether we want to admit it or not, because it's a different ballgame dealing with the younger employees, it is important that we address that issue with them, or we'll lose that talent to somebody who is willing to train and develop and move them up. And then the other area that I think is probably just as important or more so important than any of the other areas is terminations. And you're probably thinking, well, why? Well, because the way an employee leaves an organization is just as important as how you bring that person into the organization. So, you know, and I've done, unfortunately, quite a few terminations in the last couple of months, mostly for attendance, but we have had, you know, and every organization does have some conduct and behavioral issues. And discipline becomes a big part of how you handle those employees. And unfortunately, that oftentimes can lead to terminations. But how you handle the termination plays a big part in your ability to recruit additional people into your organization, because word of mouth can be a great help or it can be a great detractor. And if you are not careful how you manage somebody out of the organization, then word of mouth can cause people to say, hey, they don't treat people right over there, so I don't want to work there. And you'll have a hard time getting people into the organization. So in my experience, terminations is a huge, huge area that we have to be really careful to handle correctly. And we also have to be careful to keep in mind the legal responsibilities that we have where that's concerned. So in my little chart that I have here, I've encompassed all that with the legal responsibility, because no matter what area I'm working in at any particular time during my day, whether I'm recruiting, whether I'm hiring, whether I'm dealing with an employee relations issue or whatever, I always, in the back of my mind, am thinking about the legal responsibilities, because nobody wants a lawsuit. I don't know if any of you guys have ever dealt with the EEOC claim or anything like that, but they can get ugly. So you try to do all this and avoid those type of things. But I think, especially seeing as I've been in HR for 14 years, and I get comfortable with the things that I know and how I go about recruiting and bringing in employees, you forget that your legal responsibility starts from the moment you advertise the job. From the moment you say, I've got a position and I'm looking for somebody, you need to be considering what your legal responsibilities are. So I'm going to kind of step through the different areas that I've talked about, and I'll touch on some areas more so than others, but I'm going to start with hiring and recruiting, because like I said, that's one of the primary functions of human resources. Our responsibility is to oversee hiring and recruiting within an organization. And when I say hiring and recruiting, I'm talking about everything from the kid to the caboodle. From the time you recruit, advertise the job, screen the applicant, interview the applicant, and then actually bring them into the organization. Now, what you need to know if you're not in human resources is that there are a number of laws that strictly deal with how we bring people into the organization. And the organization that mostly enforces those laws is the EEOC, which is the Equal Employment Opportunity Commission. And they're responsible for enforcing federal laws that make it illegal to discriminate against a job applicant or an employee because of the person's race, color, religion, sex, which includes pregnancy, national origin, age. This typically deals with if you're 40 or older, and disability. And most recently, that includes genetic information, okay, and sexual orientation, because those are things that we're dealing with now in our society. So the EEOC has expanded Title VII of the Civil Rights Act to include genetic information and sexual orientation. If you look at the next slide, I've kind of put in there the different laws that the EEOC covers. The Civil Rights Act, of course, the Equal Pay Act, the Age Discrimination in Employment Act, or the ADEA, the Americans with Disabilities Act, and this is another law that's recently been amended, so now it's the ADAAA, and it includes and covers, it actually expands its coverage for people who, job applicants or employees who have substance abuse issues, who have cancer treatment, different things like that. So those protections that the EEOC gives to those people have been expanded in recent years, and you need to be aware of that. The Civil Rights Act, the Rehabilitation Act, and of course GINA, which is as recent as 2008, it was enacted into law, the Genetic Information Non-Discrimination Act. Now, if you have at least 15 employees, then more than likely, you're subject to these laws and you need to be aware of them, especially if you're doing any type of hiring or recruitment. Okay, so let's look at the Civil Rights Act. And you're probably pretty familiar with this. It prohibits discrimination in hiring, promotion, discharge, pay, fringe benefits, job training, classification, referral, and other aspects of employment on the basis of color, race, religion, sex, or national origin. So when you're talking about job advertisements, we have to exercise care in the language that we put into our job advertisements. And if you've ever posted a job, you probably know this already. There's certain things or job titles that you can't use. And you want to avoid language that reflects gender bias, age preferences, and/or limitations on age, and racial preferences, of course. Now, one thing that you may not know if you don't advertise jobs a whole lot is the EEOC is not going to penalize you if you put language into your job advertisement that encourages members of diverse groups to apply for the job. So if you put into your job advertisement that minorities and females are encouraged to apply, or you're looking for an older worker, that's okay. They're not going to penalize you for that because you're making the effort to make your applicant pool more diverse. And that's what they want you to do. If you're not sure about what job titles are okay, then you can look at the Kentucky Commission on Human Rights, their website. They have guidelines for the proper and improper language to use in advertisements. And you can also contact your Fair Employment Practices Agency, because mostly we look at the federal laws. Our mind automatically goes to the federal laws when you start talking about human resources. But there's a lot of state and local laws that apply to these things too. So if you're not familiar with them, that's a place where you can go to find out. Now, interviewing, I think if you've ever done an interview, you pretty much know there's some questions you can't ask. And they all center around singling out a particular group, whether that's for the race, color, sex, religion, or national origin. The EEOC's concern is with inquiries that have a disproportionate screening effect on members of minority groups or members of one sex. So I've listed there some things that they encourage you to, if you're going to ask questions about them, to be careful how you ask those questions and to avoid particular questions that fall into these groups. For instance, the race, color, religion, sex, you kind of know that. Height and weight, that's one thing you might not think about. I mean, who's going to ask about somebody's height and weight? But we have a position in our company where you insert coupons into a package, okay? And I'm not gonna lie, it's the worst job ever, okay? You're standing in a small spot and you're having to just put coupons into a package. It's boring, it's cold, and nobody wants to do it, okay? But if you're too tall, then it tends to hurt your back, you know? And if you're too short, then you got a little belly fat like me, it kind of rubs up against the line and it hurts a little bit. So you kind of want to find somebody that's the right height for that job. But you can't ask for somebody that's the right height for that job. So those are the kind of things that they're talking about when they're saying things you should avoid in interview questions and things like that. yeah, it's important to have somebody in that job that is the right height, but you can't specifically ask for those type of things. Marital status, the number of children, and a provision for childcare. English language skills, educational requirements.
What's the English language skill?
Well, if you have an employee that, that doesn't speak, English is not their first language, you can't necessarily weed that person out unless them speaking English is an absolute necessity for the position. You would have a hard time defending a claim if this person didn't speak English, even if you don't have somebody there to interpret, because, you know, unless it's an absolute necessity for the job, you have to give them the same consideration as anybody else. So the onus becomes on the employer to make sure that you have somebody that can speak English, also, speak Spanish or whatever the language may be, or interpret that for you. And that's what we did at Tyson. We specifically looked for some people who were bilingual because we knew that we would have employees that, you know, might not speak English. And there's some more things in the list. I'm not going to go through all of them, but you need to keep in mind that any inquiry that you cannot make in an interview is also prohibited from you to ask on your job application, okay? So it's not just in the interview where you need to be concerned. You need to make sure that you review your job application and make sure that you're not asking questions that could be considered discriminatory towards certain groups. I'm sorry, we'll stop there. Okay, now screening applicants. Once you interviewed them and you decided, okay, I'm interested in this person and now I'm gonna take it to the next step. You have to be aware that the EEOC has recently given some guidelines. They haven't said, no, you can't do it, but they are suggesting that we stop doing criminal background checks, okay? And I don't know too many people in this day and age that don't do some type of criminal background check. It's just a matter of keeping a safe work environment, which is why, you know, it's kind of difficult to accept some of the rules that the EEOC and other government agencies pass down, because in one area, OSHA is going to get onto you if you don't have a safe work environment, or you're going to be subjected to other types of liability. But then the EEOC is telling me that I can't check your background, or they're suggesting that I don't. So how do you ensure that you don't hire the axe murderer that, you know, is going to come in and create havoc in the workplace?
So they just suggest
Suggest.
that you don't.
Right. We do criminal background checks. And I'm encouraging you, if you're an employer and you do criminal background checks, to continue to do them. Because at this point, they're not saying that you can't. And it's important. What they're telling you, the guideline that they're telling you is that you need to make sure that you use any information that you get back from a criminal background check as a way to screen the employee. But it is not the end-all and be-all of how you're going to make your decision, okay? So you can still do them, but you need to be careful how you use that information.
So that cannot, that can't like completely count someone out?
I'm sorry?
So like their background check shouldn't be able to completely count them out?
Right.
What if like I work at a nursing home and that happens? I mean, you can't have someone that has abuse charges or anything like that.
Yeah.
So is that not okay?
Well,
'Cause I mean, if we were to hire them, we would end up in trouble with the state.
Well, what they're saying is you can't have a blanket ban, okay? So they're saying that you can't automatically say if somebody has this type of background, we're not gonna hire them. But there are some exceptions for, and I think I put it in here. If you need to make sure that, and I'll put it in here, to evaluate the responses with a 3-pronged test. That's what they're suggesting, or the legal people are suggesting you do. So you want to look at the nature or gravity of the offense. You want to make sure you look at the time elapsed since the conviction or the completion of the sentence if they did get convicted and they spent some time in jail. And then this is the most important part to me, the nature of the job sought or held. So if I have somebody that's going to be driving a truck for me and they just recently had a DUI conviction, then I can weed that person out, because you absolutely have to be able to drive, have a license, that kind of thing for that position. So I'm not saying that you can't use that information if you're in a profession where it's absolutely necessary that you not have somebody in that position that has that type of background. But I would suggest that you be very careful, you know, because having a license to drive a truck is very specific, you know. People can make arguments as to whether or not somebody who's had, you know, an assault on their record is not fit to work in a nursing home, okay? So I don't know how often you guys, you know, seek legal counsel when you do those type of things. I've always worked for corporations or companies that do have legal counsel, but I would definitely seek legal advice if I was, you know, in a situation where I had a nursing home or a hospital or different things like that. Because, you know, a hospital, you would expect them to take extra measures to keep the environment safe, to make sure that I'm not going to get in trouble with any of those issues.
Or a sexual predator for child care.
Exactly. Yes. So there are some exceptions to the rule, and I'm not by any means telling you don't run the background check and don't use that information to make those decisions. You just need to be careful how you use it, okay? Don't make it the sole reason why you didn't hire somebody, if you can, okay? And just be aware that one of the recent developments I was going to talk to you guys about with the EEOC is that, and I'm going to kind of skip to the, because it seems appropriate to go there right now. There's a slide in there that has some statistical information about the EEOC. And here's where the EEOC is headed. Between 2009 and 2011, the EEOC had the highest number of charges that it's ever had for discrimination, okay? And the majority of those charges were for race, age, and sex, okay? We did see a little bit of a decrease in the number of charges that the EEOC got in 2012, which is good. So there's pros and cons to where the EEOC is headed right now. They were able to reduce their pending charge inventory by 10% in 2011. That was the first reduction they've had since 2002, and they were able to keep that reduction going in 2012. That's good, because that means that they're settling claims, okay, rather than it going to more extreme measures, whether that's mediation, arbitration, or a lawsuit, okay? Now, that's good because you're able to settle the claim and nobody wants to go to a lawsuit if you don't have to. You know, juries tend to favor the employee. So you want to stay out of that situation if you can. The bad part about that is that means they're settling claims. And the last year, they were able to get $364.6 million in the claims that they settled, and they didn't even settle all the claims they had, okay? So the monetary amount that they're winning for people is going up. The charges are going down, but the monetary amounts are going up. And more now than ever, the claims that they're dealing with have to deal with retaliation, okay? Now that's an issue because when people feel like they've been discriminated against, and I think the economy plays a little bit into this because, you know, people are finding it harder to find jobs. We're getting to the point now where they can't draw on employment for 3-4 years. So they're having to find other ways to make money. And unfortunately, the employer suffers because one good way for them to make money is to file a lawsuit, okay? So they're you know, the amount of claims, that's part of the reason why they had been going up, because the economy contributed to that. The good thing is the EEOC has a plan in place to try to keep the amount of charges down and to deal with that and to settle that. But, you know, you may be out more money, you know, in the process. So the best thing to do is to not get in that situation, okay? And how you handle back, easy way to do that nowadays. You know, before you didn't too much hear anything about that, but nowadays people are having a harder and harder time finding a job, and the easiest way for them to, you know, make a claim of discrimination is to say, hey, they didn't hire me because I was black, or they didn't hire me because, you know, I had this conviction on my record. And I told them I had a conviction, but they still didn't hire me, even though that may not be the reason why you didn't do it, okay? So you just have to be careful to step lightly when you're dealing with those situations, okay? But the EEOC is definitely seeking higher and higher settlements for those type of things. Okay. I'm gonna talk a little bit about gender identity. I haven't ever had an issue where I've had a claim for gender identity. And this is something that's still pretty new. But the EEOC has held that job bias on the basis of gender identity amounts to sex discrimination under existing law. And the commission has also found that claims by lesbian, gay, and bisexual individuals alleging sex stereotyping state a sex discrimination claim under Title VII, which is a new thing for us to have to deal with, okay? So I just wanted to make you guys aware about that. I don't want to spend a whole lot of time on it. Do you guys have any more questions about background checks or anything like that? I'm moving kind of fast because I'm trying to cover a lot of information, but I don't want to discourage you guys from asking questions.
Two questions. What about credit checks? How does that play into it?
You know what, I didn't really get into it in this presentation, but if you're doing credit checks, then the Fair Credit Reporting Act requires that you do disclosure, that you get written consent to do that, but the EEOC is not putting more emphasis on that than they ever have. You know, they're still treating that pretty much the same. And they're treating it the same as they are the criminal background checks. You can still do those reports. They're asking you to be careful how you do that information. They're not saying you can't do it. But you you'd still have to get consent to do a background screening from an employee. But with the credit reporting, you have to, if you use that information to disqualify somebody from a job, where you get in trouble with that part of it is not letting them know that's why so you're bound, you have to let them know. You have to provide them with the information about what agency you used and give them the opportunity to contact that agency to verify that information, correct it if it's wrong, and that kind of thing. But they're not saying that you can't do those type of checks, okay? They're not putting any more emphasis on that than they have in the past, okay? So you're pretty good with it. If you've been doing it, you're pretty good. And we do them at Land on Frost too.
The other question I had was, when you asked on the application about address, I noticed on NBC they had talked about being able to pinpoint a person from where they live by either phone or address and then use that information
Yes.
on whether they're desirable or not.
Yeah. And I won't lie, the social media and the different types of technology like that are presenting a bit of a problem as far as being able to stay unbiased in when you're looking at applicants. And I don't know a whole lot of cases that have come up where somebody has gotten into trouble for that part of it. It's usually a termination as a result of some type of negative thing they did towards the company using social media. But I really expect us to get some more guidance on that as things go along. To be honest with you, I think they're kind of afraid to, put any black and white anything to it because you really can't control it, There's nothing that they can do to control whether or not you go on the internet and check somebody's Facebook or, pinpoint their address or anything like that. So actually putting out a law or some type of regulation that controls that is almost impossible at this point. So that recent developments, that's one of the things that is definitely, I think we're going to hear more about as we go along. But right now, they don't have a good way to control it. So, if they can't control it, then they're going to continue to issue. And keep in mind that the EEOC doesn't go looking for issues, okay? So, in all honesty, an employer could probably do some of these things and never get caught. What the EEOC does is they respond, as of right now, to a claim. So when the claim is actually set, that's when you gotta worry, because they're not just gonna focus on that claim. They're going to focus on every applicant that you've looked at within a certain time frame. One of the claims that I got when I worked at Tyson was a discrimination claim. They asked for every application, a copy of every application that we had taken in within the last 2 years. Now, when I first got to Tyson, we were turning people over left and right. Our turnover rate was astronomical. We had over 8,000 applications within that 2-year period, and we had to copy every one of them. And one of the things that I learned while I was at Tyson is don't write on an application, okay? Because anything you write on an application can be used against you in court of law, okay? Unfortunately, when we were doing that, we were actually writing on the application. We would write a code on there as if we didn't hire them, why we didn't hire them, we write the code on there. We might make a comment about, if they got irate in the, in the waiting room, or they didn't show up for their interview, we'd write a comment on there. Well, we had to white out every comment and everything we wrote on those applications before we sent them to the EEOC, because we didn't want them to use that information against us. So corporate made us go through 8,000 applications and white out anything that we had put on there.
You
So
couldn't be held responsible for whiting it out.
Well,
We had information.
we weren't in that situation,
Yeah.
unfortunately. But we learned really quick that you don't do that type of thing. And you have to keep that in mind. When I talk about the legal responsibilities that encompass what we do in HR, they're all encompassing. The things that you wouldn't think would get you in hot water can, and that was one of them. So from that point on, I never wrote on an application. But, you have to be conscious of the fact that once that claim is filed, it's fair game. Doesn't matter, they're not just gonna look at that applicant, they're gonna look at all the applicants. And whether or not you have a pattern of discriminating against a certain race or a certain person of a certain sex or that kind of thing. So you just, you have to step lightly, okay?
Like with us, we have what's called an interview guide. When we interview, like I'm a branch manager for the bank, and we have an interview guide. What does that say into it? Because we actually have to write, down stuff on there.
Once again, that becomes part of your record. So if you do have some type of claim, whether it's discrimination or whatever it may be, you can use that to show that the consideration that you've given to each employee. And I didn't get into interview questions a lot, but people more so now are getting into behavioral interviewing, because that's a way to get around all those things that I can't ask you, but I can still kind of find out what kind of person you are before I bring you into this organization. And we do the same thing. We have interview packets. We ask, because you want to ask the same questions. And I think the packets are more so for people who are not in HR, who are not as familiar with the law. It's a way for us to say, hey, here are the safe questions you can ask. Ask what's in the packet. Don't ask anything else unless you ask me first. and it's a record that we can put away to show that, hey, we treat all our applicants the same. Look, we ask them all the same questions. We give them all the same consideration. So that, to me, that's where the interview packet comes into play. It's not just to show that you're being fair and consistent in how you recruit and hire employees, but it's a good tool for your managers who don't necessarily care about all the legal obligations that you have, to make sure that you stay out of hot water and they don't ask questions they're not supposed to. Does that kind of answer your question? Okay. All right, any other questions about EEOC, background screenings, that kind of thing? Okay, hiring applicants, and Vanessa, you might have to keep an eye on the time for me, because I was afraid I wasn't gonna make it through all of this, but I wanted to spend some time on recruitment and hiring, because I don't know about you guys, but if you do it, that's what I spend the majority of my time on. Now, pre-employment physical is another area where you may have questions about whether or not I can or cannot do that. You can, okay? And we currently don't do pre-employment physicals at Land & Frost, but everywhere I've worked at before we have. But the ADA prohibits employers from requiring physical examinations before making an offer of employment. So your limitation is that you can't require an applicant to do the physical until you've made them a job offer, okay? You can make a conditional offer of employment based on the results of a pre-employment physical examination if you do it for every applicant, so you have to be consistent. And believe me, my supervisors and managers, they get tired of hearing me say, you gotta be fair, you gotta be consistent. But it is a huge part of being able to defend yourself when you do have a claim. You gotta be fair and you gotta treat everybody the same. You have to make sure that you keep the medical information separate from all other information and you treat it as confidential. Okay, I don't know how many of you guys are familiar with FMLA and that kind of thing. Any type of medical information you get, even if it's a doctor's excuse, has to be kept separately from the rest of the employee's personnel file. So we have a personnel file, we have a separate medical file, we have a separate benefits folder, okay? Because sometimes you get benefits information that crosses that barrier of being medical or strictly just information you're using for benefits, so we have separate files for those as well. And then the results of the examination are used only in accordance with the ADA, which is saying a whole lot, because the ADA, and like I said, in recent years, it's been amended. It has expanded its coverage for people with disabilities. So you need to make sure that you are aware of what that coverage is, okay? And I didn't get into this a whole lot, I didn't get into the ADA a whole lot in this presentation, because it is a lot to cover. But you can find out a lot about these laws going to the EEOC's website. It is, I like their website. You know how you go to some websites, it's hard to find information? I like their website. So it's www.eeoc.gov, okay? And you can go over there and check out any of these laws. Hiring applicants. If you don't know, which I think most people do if you hire applicants, that you have to report in Kentucky every applicant that you hire, every new hire, I'm sorry. It's part of a nationwide effort to collect child support payments. So all public and private employers in Kentucky are required to report each newly hired employee to the Commonwealth of Kentucky within 20 days of hiring, okay? And I think most companies do this anyway, but you know, for our company, it's done electronically. Once we put them into our system, they automatically shoot them a electronic communication every twice a month that reports who our new hires are. Now, here's another thing that you kind of get into when you're hiring employees, and I'm thinking about the HR basics. You can't really think about the HR basics without at least considering employment at will. I mean, we deal with that all the time with supervisors and managers who think, you know, I don't like Joe Blow. He doesn't show up for work on time, you know, he's a pain in, you know, whatever. And I want to get rid of him. Why can't we just fire him, you know? Especially when you're a non-union facility. They think, you know, we should just get rid of him because employment will says we can. But you have to keep in mind that there are some exceptions to that law. So, you know, if you just look at the law itself, yeah, you can fire an employee at any point, at any time, for any reason, so long as you've established that from the time you hire them. But if you are firing an employee for something that can be considered a statutory claim, then you have to make sure that you have just cause to do that. So if you've got somebody who's been milking the FMLA, or they come to you and they say they've got a disability, you want to be careful how you handle that situation. Because, you know, it's easy for us to say, you know, they're a hassle and it would just be easier if they weren't here. But you have to be careful how you handle those situations, because those can be very much so a legal obligation. And you want to make sure that if you have an employee handbook, or if you do offer letters, that you mention in your employee handbook or your offer letter that you are an at-will employer. Now, you can get, there's some good and bad to that. You can get in trouble if you're not careful how you fire somebody when you're looking at will. But it's very important that you establish that you have an at-will employment capacity when you bring an employee in. Because if you don't, then you may get in trouble with issues around a breach of contract, okay? Or some type of implied employment contract. So if you're giving an offer letter and you tell them we're going to pay you so much per year, and then 6 months down the road you decide, you know, you don't like this employee anymore, it's just not working out, and you fire them, if you haven't established that at-will employment, then they can sue and probably make a pretty good claim that you owe them the rest of their salary for the year. Because you had an implied contract that they were going to be here for a year. You said he's going to pay me so much, you know, per year, and I wasn't here a whole year, so you needed to pay me the rest of the money. Okay, so you have to be careful with that at-will part of it. Compensation and employee benefits. I'm going to run through this really quick. If you,
LaSenna, I'm gonna
Yes.
ask you a question.
Mhm.
companies that downsize, is there any type of requirement that they, if they're trying to cut a real highly paid position, I'm sure there's not a requirement that they offer you a less position in the company?
I don't know of any requirement where they do that.
Okay.
Now, you may run into some issues with the ADA, if there's a perceived disability there or an established disability there, maybe even the FMLA to some degree. If that person is still capable of doing their job, but just not in the capacity that you want them to be in, you may have some situations where you need to find them another position to put in. But when you start talking about highly compensated employees, the law views them a little bit different than they do everybody else, okay? So I can't really tell you anything that I know of for sure that would keep you from, that would require you to do that, other than if it was some type of medical issue that might be considered a disability. You know, then you may have some requirement there to make some type of reasonable accommodation.
And I have one more question before you go on to a different topic,
Mhm.
before we run out of time.
Yeah.
Some of our businesses in our area are smaller businesses, so they can't afford to have an HR person on staff. Are there any types of people with the HR education credentials that can, like, contract work for them? And how
Yes.
do they get in touch with those people?
Well, and because I don't know of any in this area right off the top of my head that actually do consultant work, and they may, and I just don't know it. I know of what Amy, actually, the lady that was supposed to come with me, has done some consultant work. But you can definitely, there's a lot of employment agencies around that do that type of thing. You can outsource those type of resources. And the best way that I know to tell you how to find those type of resources is to use a contact that, through SHRM.
Okay.
So if you wanna shoot me an email, I mean, I guess if you're looking for something like that, or if you guys wanna find out some more information about that, shoot me an email, and, I can send that information out to our SHRM group and get some contact information for you. That's usually how I find out those things. I really, really enjoy being a part of SHRM because it does, open up the doors to those type of contacts and things like that, but I would definitely encourage you to use that resource. Of course, you could, I mean, in my opinion, the best resource is a personal contact, somebody you know, rather than just kind of getting on the yellow pages and picking the first employment agency you find. But if you want to shoot me an email, I'll see if I can get some contacts for you for that. How much time do we have left?
You really have like 5 minutes and
Okay.
more question time.
Okay.
If anybody needs to leave, that's okay.
Yeah. All right, so I won't spend a whole lot of time on compensation and employee benefits. I was just gonna say that, the FLSA, the Fair Labor Standards Act, when we talk about basic HR stuff, that's one of the laws that plays a huge role in human resources and how we compensate and pay our employees. So if you're in that type of role where you're handling payroll or anything like that, then you definitely want to make sure that you're in compliance with the FLSA. And the Department of Labor enforces that law, and the DOL is another website that I enjoy. It's dol.gov, and they have a lot of compliance materials on that website, and explanations, fact sheets, different things like that kind of explain how to stay in compliance with the FLSA. So that's a good resource to look at. Now, real quick, I'll talk about healthcare reform because we all know that that's one of the biggest developments that we've had. The Patient Protection and Affordable Care Act. And you know, I would love to tell you that I'm going to enlighten you on some things about this act, but I'm really not, okay? There are several things in the act that have already gone into effect. And I didn't really go into those things in here, but this act is so extensive. I mean, it is complicated, it's huge, and there are a lot of things that are undecided at this point, okay? Some of the things that have already been enacted, they're gonna go away as of next year. And some of the things that have not been enacted are going to go into effect next year. I don't know about you guys, but we've already started reporting the employer's portion of the benefits that they pay on their on employees' W-2. That is a big part of the act that is going into effect next year. So if you're not already doing it, you'll be required to do that as of January of next year. So this act is, there's a lot of things to consider, and I'm by no means an expert on this act. I have to know some things about it because we deal directly with the employees and they have questions about it and we need to be able to answer it. But we do have a corporate benefits department that is really dealing with these issues more so than I am. But there are several reporting requirements that are gonna come into effect next year. And there's also the penalty portion of the Healthcare Reform Act that's gonna go into effect next year. So as of January of next year, the ACA is gonna require most individuals to obtain acceptable health insurance coverage or pay a penalty. And that's supposed to start in January of next year. And that penalty will start at $95 per person, and it'll increase each year up after that. And I believe, if I remember correctly, it goes up to like some crazy amount, like $600 or more. So that's one of the things that are gonna become a big issue. And I suspect that we'll start hearing some things about how they're gonna enforce this, how they're gonna keep track of this. And everything that I understand about this act at this point puts a lot of the administrative burden on the employer, okay? We're gonna be required to report to them what our benefits are from top to bottom, how much that's costing us, how much we're charging the employees. If we use a third party, they may bear some of the responsibility for that reporting requirement, but all that information is going to have to be reported to the IRS, okay? So if you're not already gearing up for the changes that are coming next year, then you probably need to be thinking about it. Probably need to be finding a good resource to kind of guide you through that part of it, because it's a lot that's coming up. There's also gonna be a penalty to employers if we don't offer coverage that the employees can't afford, or if we don't offer coverage at all. That penalty is supposed to go into effect next year, okay? And it could be up to $2,000 annually for each full-time employee, excluding the first 30 employees, okay? And that can get pretty expensive. Now, I'm sure you guys are all aware of the debate that they've had, do you pay the penalty or do you try to offer the coverage, And I don't think anybody really has a good answer for that right now. Because the other thing that they're gonna have to come up with, somehow or another, it's gonna have to work out next year, is there's supposed to be this health insurance exchange, okay? And how is that gonna play into whether or not I need to offer health insurance to my employees, or whether it's more beneficial for me to just say, you know what, I'll pay the penalty and you can go find individual coverage on the exchange. It's cheaper for me to do it that way. So, employers are up against a wall right now. And you can debate about whether or not you feel the Healthcare Reform Act is a good thing to have in place or not. I think in theory it's good, but as far as the administrative part of it, and our federal government is so not good about administering the policies that it puts in place. I cannot imagine what next year is gonna be like. I am waiting with bated breath to see what even our employer does to try to stay in compliance with these laws, because I don't wanna say they're making it up as they go, but that's pretty much where we're at this point, They're figuring this stuff out as we go. And I'm concerned that as they're figuring it out, people are gonna get to next year and they're not gonna have certain things in place and they're gonna get penalized for it. So I would love to tell you black and white what you need to do to be in compliance with this law, but I can't. Because I don't think at this point we all know. Like I said, there's some things that you should already have in place or that are required to have if you have the health insurance coverage for your employees. But the other stuff, I think the next 6 months are gonna be hairy as far as us trying to figure out how we're gonna stay in compliance with this law. So keep your eyes and ears posted because it's gonna be a lot of information to try to take in and figure out how you're gonna deal with, especially if you're a small employer. Now, there are some exceptions, you know, for small employers. They're trying as much as possible to lighten the financial load to the small employer to be able to encourage them to offer healthcare insurance, because that's what they want. They want the employers to offer the insurance. But I can definitely see both sides of the coin where the employer's just like, hey, you're telling me if I give you a Mac Daddy health insurance coverage, but my employees, for whatever reason, can't afford it, then you're gonna penalize me for that, you know? It's crazy. I'm just being honest with you. It's a mess right now, so it'll be real interesting to see where we go from here.
Sorry,
Mhm.
we better just do questions. If she didn't hit something y'all wanna know.
The point of interest is that reporting that on the W-2s, that's probably gonna come into a bad point later on. But as far as retention on employees and employees actually seeing the benefit and the cost of benefits, that's gonna be a plus for HR.
Yeah, it is. You would like for it to be, okay? Because employees definitely forget about that part of it. And we've been trying, as part of our engagement, to figure out how can we show employees that that's part of their compensation. They don't see it. You know, we always get on our survey that we need to be paid more, we need to be paid more, but that is a huge part of an employee's compensation. And you're right, that W-2 is one good way to show them, hey, look how much money the company is paying towards your healthcare insurance. You're arguing with us about how much our deductible should be and, you know, what the copay should be, but, you know, the company's covering $20,000 or more for you to have that healthcare coverage, so you're right.
So that is gonna be mandatory in
Yes.
14.
If any of you all have questions for your staff or whatever, we had a speaker do from Peel and Holland, and it is on a YouTube video on the chamber website.
Yeah. And I'll tell
If
you,
wanna learn more.
another good resource is the Kentucky Chamber. They're putting together, if you haven't already gotten some information about it, they're having a healthcare reform seminar or whatever you want to call it. One's going to be in Louisville, one's going to be in Lexington. It's on May the 8th and the 9th.
It's very confusing.
It is. And I'll tell you what, I've been, because honestly, I'm a generalist. I'm in the plant. I don't have to deal with, you know, the implementation part of it. But I've been to 3 or 4 different seminars and I'm still confused, you know? It is just a huge amount of information to try to convey. And then even the experts can't tell you what's next. You know, they can't tell you how they're gonna handle the exchange. They can't tell you, you know, what the administrative burden is exactly gonna be because they don't know yet. I'm serious, the federal government is just playing us by ear right now. So, you know, I would encourage you, if you have anything to do with that part of it, to go to as many seminars as you can because it's gonna be important for us to stay in compliance, even though the government is not making it necessarily easy for us to do that. Any other questions? I'm sorry my presentation went a little long. I'll be honest with you, this was my first time actually doing a presentation like this, so I wasn't really sure how much time I would be able to use for each of this, for all of this, so I'm sorry that I didn't make it all the way through, but hopefully what I did cover was helpful to you, and I'd be happy to, as much as possible, answer any other questions you have.
Could you just give us like a few pointers on terminations?
Yeah, let's look at the slides that I actually put together because I'm a huge believer, especially since I have dealt with it a little more here lately than, you know, that you have to absolutely be careful how you terminate an employee. It can make or break you, okay? If an employee leaves the company badly and they feel like you've done them wrong, you can just about depend on getting some type of claim. It may not be a lawsuit, it may just be an EEOC claim, which right now could cost you a whole lot of money. Even an unemployment claim, you know, can be difficult. So one of the things that I like to do, the first thing I would advise you to do, if you have anybody that is handling terminations outside of your assistance as a human resources person, I would advise you to put a stop to it, okay? Nobody should be terminating people if you have human resources on site. Now, I'm just saying, if you got an HR person, they should always be involved in the termination, okay? The other thing that I would advise you to do is to make sure that you train your supervisors and managers, because really your supervisors and managers you depend on them so much to make sure that by the time you get to a termination, they have handled things as well as they possibly can.